Well, welcome. My name is Adam White. I'm the director of the C. Boyd & Gray Center for the Study of the Administrative State here at George Mason University's Antonin Scalia Law School. On behalf of the center, it's my pleasure to welcome you to the George Mason Law Review's first annual symposium on administrative law. Our subject, as you know, is agency adjudication and the rule of law. Before I introduce the conference and the first panel, let me turn things over to the law school's dean, Henry Butler, for a few words of welcome.
Good morning, everyone. Adam, congratulations on putting together another outstanding program for the C. Boyd & Gray Center for the Study of the Administrative State. This center is a reflection of many other types of programs we do at the school. We've taken advantage of, we've created kind of what I would consider an academic entrepreneurial environment by having a number of different centers. So we've got our Law and Economics Center, which is our flagship center, which has been around since 1974, runs a variety of programs for economics for judges, for state attorneys generals, for law professors, all very tough audiences to work with. But we've been doing that for a long time, sponsoring a lot of the research in the school. A few years ago, we spun off an organization, the Global Antitrust Institute, which is thriving under the direction of Josh Wright. The Center for the Study of the Administrative State actually grew out of some programs that we were doing at the Law and Economics Center as well, and we decided to go forward with this. We also have the Center for Protection of Intellectual Property, which is run by Adam Mossoff, which holds dozens of programs a year as well. So we use these centers to actually trigger a lot of research around the school, a lot of involvement by bringing professors in from other schools, and we actually fund a lot of research by professors at other schools because we're trying to build really a dynamic, competitive marketplace of ideas. And so for all of you who are participating in the program, thank you very much for joining us and being part of that marketplace of ideas, and we very much appreciate everyone who's attending this. Thank you and have a great conference.
Well, it's an honor to co-host this event with the George Mason Law Review, and all the more so because of the quality of the legal scholarship that many of the speakers today have written for this symposium. When we selected this topic in the spring, we understood that the Supreme Court's eventual decisions in the Lucia case and oil states could raise as many questions as they answered with respect to the relationship between agencies and courts, agency adjudication and constitutional judicial power, public administration, and the rule of law. These have always been interesting and nuanced questions because the line between adjudication and judicial power is not always self-evident. As Justice Scalia observed on the subject of non-judicial tribunals in 1991's Freitag case, quote, "It is no doubt true that all such bodies adjudicate, that is, they determine facts, apply a rule of law to the facts, and thus arrive at a decision. But there is nothing inherently judicial about adjudication. To be a federal officer and to adjudicate are necessary but not sufficient conditions for the exercise of federal judicial power, as we recognized almost a century and a half ago. In short, courts have grappled with modern questions of agency adjudication and judicial power for decade after decade. And for that reason, and if anything, Lucia and oil states may reinvigorate those debates. And for that reason, the center is grateful for the papers that our authors have written, which I think will be of great value to the scholars and judges of the years ahead. And we also thank the editors of the Law Review for all their own hard work in helping the editors to finish these papers. And on that note, let me please join me in welcoming the George Mason Law Review's Editor-in-Chief, Gabriella Mahan, to say a few words. Gabby?
Thank you, Professor. Can everyone hear me? Okay. As Professor White mentioned, my name is Gabriella Mahan. I'm the Editor-in-Chief of the George Mason Law Review. We're very, very happy that you're here. I'm going to be very brief so that we can get started with our panel, but I just had a few quick words to say about how excited we are to partner with the center, the C. Boyd & Gray Center for the Study of the Administrative State, in our first ever Administrative Law Symposium. Not only are we excited to staff and participate in the event, but also excited to publish 10 of the authors who you will hear from today in our winter issue. And as you can expect, we're thrilled to get our hands on such high-quality scholarship and on such important topics as agency adjudication and the rule of law for our winter issue. So this is quite the opportunity, and I thank Professor White and the C. Boyd and Gray Center team, and especially the authors for the opportunity, so thank you. And as I'm sure you're interested in doing, you'll be able to access these publications on our website, which is georgemasonlawreview.org, as well as on the normal publication websites such as Lexis and Westlaw. We also print, and you can purchase a subscription to the George Mason Law Review, and you'll see that in actual paper form. We publish about 5 issues per semester, per term, per year, yes. 5 issues per semester would be a little much. And our production process just began this week for these publications, so we're very thrilled to get that pushed out, and you'll probably see a print version of that by February of 2019. So now to close, I just wanted to say a very gracious thank you to both Professor White and his team, specifically Leah Verbitsky, who's been so helpful and excited about our partnership. We do hope that this is the start of a very long relationship between the George Mason Law Review and the C. Boyd and Gray Center. I also wanted to thank Dylan Nagley, our Symposium editor, without whom we probably would not be here. He's been working extremely hard to shore up very healthy and impressive relationships with our partners, both on campus and off. And finally, to the members of the George Mason Law Review who are here today volunteering, you'll see them handing out microphones and staffing the registration table, and even attending the lunches and the lectures. If you have a chance, just say hello to them. I'm sure that they would be really excited to meet you all. They're very excited to be here and also to participate in the event. So without further ado, I'll let us get started on our panel. Thanks for being here.
And just one last introductory note, we keep referring to the C. Boyd and Gray Center. Well, as it happens today, it's our honor and pleasure to actually be joined by Ambassador Gray, who's here with us today, and without whom our work would not be possible. So thank you very much, Ambassador Gray. Thank you. All right, well, on to the first panel. Later in the day, we'll have panels focused more specifically on the 2 big cases from last year, Lucia and Oil States, and their implications. But we thought we'd open the day with a broader discussion of agency adjudication and the APA and the rule of law in general. And so we've brought together 3 authors and a commentator to discuss the new papers that they've written for the George Mason Law Review on this very broad subject of the role of agency adjudication in our current system of government. So let me briefly introduce each speaker in the order that they'll present. Their full biographies are in the program, but very briefly, let me say first that Michael Asimov is a long-term visiting professor at Stanford Law School and professor of law emeritus at the UCLA Law School. Having authored many books and articles, his next book is particularly relevant to today's discussion. The book is titled The Source Book on Administrative Adjudication Outside the Administrative Procedure Act. It will be published this year by the Administrative Conference of the United States. Is it already out? It is already out?
Oh, no, not yet.
Coming soon to Amazon websites near you. The second will be Thomas Merrill. He's the Charles Evans Hughes Professor of Law at Columbia Law School. He previously taught at Yale and Northwestern and served for 3 years as a Deputy Solicitor General in the Justice Department. His administrative law articles have influenced a generation of scholars, students, and judges, especially his 2001 article, Chevron's Domain. Our third speaker today is Michael Rapaport. He's the Hugh and Hazel Darling Professor of Law at the University of San Diego, where he directs a program called, and I do like the name, the Center for the Study of Constitutional Originalism. There's so many centers with so much to study. He teaches and writes widely on originalism and the Constitution's separation of powers. With Professor John McGinnis, he co-authored Originalism and the Good Constitution, published by Harvard University Press in 2013. Finally, to comment on the author's papers and offer some further thoughts, we welcome Aditya Bomzai, an associate professor of law at the University of Virginia. Professor Bomzai previously served in the Justice Department's Office of Legal Counsel and National Security Division after clerking for Justice Scalia. His scholarship explores, among other things, the historical underpinnings of administrative law doctrines, as in his 2017 article, The Origins of Judicial Deference to Executive Interpretation. So we welcome all of our speakers, and let's begin with Professor Asimov.
These?
You might need those.
So good morning, everybody. Thanks, Adam, for inviting me. I've really been looking forward to meeting all of you and to hearing all your questions about my work. So as I contemplate my fellow panelists as well as others who are speaking during the day, I kind of wonder if I'm in the right conference, because most of the people you're going to hear, not all, have a very global view of reforming the system of administrative adjudication. My paper is not like that. This is much more of a worm's eye view rather than one from outer space. But it is equally designed to promote the rule of law and to make adjudication better. So I'm going to be discussing evidentiary hearings outside the APA. And my goal today is to introduce you to this very large universe of adjudicatory proceedings and convince you that they are an important and distinct type of adjudication, where rights are protected not much by statute or by due process, but by internal administrative law. I want to persuade you to stop calling them informal adjudication, which you all do and which I used to do, and then I'm going to speak a little bit about best practices. So this work got started too many years ago as a project for the Administrative Conference of the United States, for which I was the consultant. It began with the construction of a huge database by ACA staff. It was an enormous commitment about all federal adjudication. That is publicly available and is a valuable resource for anyone who wants to do research in the nuts and bolts of federal adjudication. I completed a study, and it led to ACA's recommendation 2016-4 about best practices for non-APA adjudication. It has resulted in a book, which Adam mentioned, which will be published later this year, and finally in this much shorter article and my talk today. I also want to mention the work of Kent Barnett, who will be speaking today, although on a different subject. Kent also did a study for the Administrative Conference on this subject of non-APA adjudication and came up with some very meaningful and excellent recommendations for protections of the independence of administrative judges, although they didn't result in an ACAS recommendation. Is that working? Good. Okay, that's already covered that one. So now I want to introduce a typology of federal administrative adjudication. This is really fundamental to the work that I've done. Type A adjudication, that's the part you know. That's the APA adjudication sections. Hearings presided over by administrative law judges. Everybody's familiar with that, very extensively studied, not the subject of this paper. Type B adjudication, which is the subject of this paper, are federal evidentiary hearings, legally required evidentiary hearings that are not covered by the APA. This is a very large universe of proceedings and very important. It's presided over by somebody, not an ALJ. I call them administrative judges, AJs. Kent calls them non-ALJs. You can call them presiding officers or hearing officers, and in fact, they have all different titles all over the federal government. But I'm going to refer to them generically as AJs. And then type C adjudication Type C adjudication are not legally required adjudication, defined as individualized determinations by the federal government, but not in a legally required evidentiary hearing. There's an enormous number of those. Not covered today, but my book will cover type C adjudication and suggest best practices for them. So type B adjudication, that's what we're talking about today, very large and important area, is an evidentiary hearing. So I had to be very precise about these definitions because the best practices are limited to type B adjudication. So, excuse me, an evidentiary hearing is means legally required opportunity to introduce evidence, rebut the opponent's evidence, a neutral arbiter, and most importantly, an exclusive record. That is, the decision in the case comes from the inputs that occur at the hearing and not from other things that the hearing officer happens to know. So evidence at the hearing plus, of course, official notice. So this excludes quite a lot. It excludes so-called public hearings where the public comes in to let off steam. Sorry, in this slide, the next word should say non-evidentiary hearings, since this would wipe out my entire subject the way it's up there on the board. So it's non-evidentiary hearings, investigatory hearings, and frontline decisions. So frontline decision is like when the SEC decides to issue a complaint against you. That's an adjudicatory type decision, but I call it frontline because it can be followed by, will be followed by, a de novo hearing before an AJ or an ALJ. So we're excluding frontline decisions from the best practices that are being suggested here. So an example of, in my opinion, a frontline decision is at the very important Patent Trial and Appeal Board. They consider, and you'll hear a lot about the so-called inter partes proceedings before the PTAB. Same thing in the Trademark Trial and Appeal Board. Those are private versus private cases adjudicated by that board. But they also consider decisions by patent examiners. So a patent examiner denies you your patent that you've applied for, you then get a de novo hearing before the PTAB. So the decision of the patent examiner is a frontline decision because it can be it will be followed by a full de novo hearing. So all of us, myself included, have referred to Type B adjudication as informal adjudication. And it covers this vast area of very important decisions. Immigration, veterans benefits are the two hugest ones. The PTAB, very important. Contract Board of Appeals, Merit Systems Protection Board, many, many others. My study and my book have in-depth treatment of 12 of the most important Type B adjudications systems, but there are, of course, many others. So, are they informal adjudication? No, they are not informal adjudication. They are just as formal as Type A. They are more formal than most Type A. Most Type A hearings, that is APA hearings, are Social Security and Medicare cases, the vast, vast majority. Those are informal, right? They're inquisitorial. The ALJ wears three hats, represents the government, represents the claimant, and makes a final decision. Many of them don't involve, they're quite informal. Whereas Type B, many of them are very formal. PTAB, for example, uses the federal rules of evidence, uses federal discovery rules. It's entirely like a federal district court decision in a patent case, except it's not being heard by an Article III judge. It's very formal. So if you go around calling these informal, that's a serious misnomer and is going to confuse your students. So that's why I'm calling them Type B. Some people like to call them semi-formal, as opposed to formal or informal. But whatever you do, I think it's an error to call them informal. Type C adjudication, now that's informal, because there's no legally required evidentiary hearing. Now, a lot of people thought, and I used to think, that Type B adjudication is like a black hole. The government can do whatever they want with whatever procedure they want, subject to a very small limit of what due process requires. Due process does apply to some of them, like immigration, doesn't apply to others, but due process doesn't require very much, as we all know. So it's a black hole, right? As my paper says, abandon hope, all ye who enter here. This is false. This is wrong. There is a very detailed set of required procedures in Type B adjudication, but you don't find them in a statute or in due process. You find them in procedural regulations. Quite a bit of scholarship in this field recently has been devoted to internal administrative law. Jillian Metzger and Kevin Stack have written very well about this. Internal administrative law means administrative law generated by the agencies themselves, as opposed to by a statute or by a court decision. And that's the case here. If you study this, you will find very rich and detailed sets of procedural regulations for every Type B adjudication. Sometimes it's procedural regulations published in the CFR. Sometimes it's in procedural manuals that ought to be in the regulations, but nevertheless are still followed. But I think you will find, if you study this very rich source of procedural protection that agencies didn't have to adopt, but have adopted. So given that, that was the jumping off point for my study. If it's going to be in procedural regulations, what should those regulations look like? What are the best practices for procedural regulations for Type B adjudication? Now, obviously, Type B is all over the map, from very important matters to very trivial matters, some complex, some simple. So you can't adopt a single procedural code applicable to all of them. They really vary too much. But the goal here in ACUS recommendation 2016-4 and in my work was to come up with a set of best practices that should be in those procedural regulations. So as new Type B agencies are created, and there will always be new ones, they will need procedural regulations. Some of the older ones need to revamp their regulations. When they do this, what should those regulations look like? What are the best practices? So I don't have time in my brief 12 minutes that Adam has given me here. How am I doing?
3? Yeah.
Okay. So let me just give you a quick view of what these best practices are, and if you're curious, you will find them more discussed in my paper. The one thing you'll notice is that they look a lot like the APA, except you don't have ALJs. You have administrative judges, but there are protections for the integrity of the decision, such as separation of powers, prohibition on ex parte communications, freedom from bias, in other words, integrity of the process. It's all there. It's in the procedural regulations. For most of these, some of them could be clearly improved, and that's the goal here for adopting best practices. Pre-hearing practices, such as proper notice and discovery, what happens at the hearing, such as rules of evidence, alternate dispute resolution methods, the ability to be represented by counsel, or best practice, in my opinion, the ability to have a lay representative, a non-lawyer representative, very, very significant in this field because lawyers are way too expensive. Post-hearing, that is a requirement of written decisions, there should be some sort of internal appellate form of reconsideration. Most of them have this. PTAB does not, and that's a design flaw in the PTAB. But in general, there is some sort of internal appeal. It might be to the agency head, it might be to designated reviewers, but some opportunity to get a second crack at the case after the AJ decision and before judicial review. So can't go into detail about the best practices. But I hope what I've left you with is a recognition that there is a very large universe of federal adjudication not in the APA. Oh, by the way, just to head off the question you're going to ask me, my title is Evidentiary Hearings Outside the APA. This is a little misleading. I admit it. They are subject to the APA provisions, sections 555 and 558. Those are primarily applicable to C adjudication, but they apply across the board. And of course, they're subject to the judicial review provisions of the APA, but they're not subject to sections 554, 556, and 557, the adjudication provisions of the APA. So my title, a little misleading, but I hope I've persuaded you that this is a large, important body of administrative adjudication that deserves to be studied as a single group as opposed to just agency by agency. It is not informal adjudication. It's often quite formal, and that it is possible to come up with a set of best practices that will be good for all of the people who appear before those agencies and will promote the rule of law. Thank you.
Professor Merrill.
Oh, thank you.
Again, good morning, and thanks very much to Adam and the Center for inviting me. It's a great pleasure always to come to George Mason and talk about things that really matter in the legal profession. My talk today is entitled Fair and Impartial Adjudication, and I think it falls within what Professor Asimov characterized, maybe with a slight tone of disparagement, as a global approach to this issue. I'm really going to talk about constitutional law and what the Constitution says about fair and impartial adjudication, reflecting my own views of constitutional law, which are different from Mike Rapaport's. I have sort of an evolutionary sense of constitutional law. It starts with the original understanding, but then takes us forward to the present day. So the Constitution contains two different strategies for assuring fair and impartial adjudication. One of them is contained in Article 3 of the Constitution, the other in the Due Process Clause, originally applicable only to the federal government, but then extended in the 14th Amendment also to apply to the states. Now, why does Article 3 contain a strategy for fair and impartial adjudication? Partly because of what it says and partly because of what it doesn't say. So what Article 3 says is that the persons appointed to the federal bench will be independent of the political branches. They can serve during good behavior, which has been understood to mean as long as they want to for life, and they have secured compensation. Their pay can't be reduced as long as they're serving. If that's all we had in Article 3, independence, and let's say Article 3 also included a provision that said that federal courts could charge fees to the parties appearing before them and could use those fees to hire policemen to enforce their orders, I don't think we would necessarily get fair and impartial adjudication. What we would get would be an imperious judiciary. But Article 3 is also notably silent about giving any power to these Article 3 judges to enforce their judgments. By implication, the Constitution quite clearly gives that power to the executive under the duty to take care clause and to Congress in terms of its authority to fund the executive branch. So how do you get fair and impartial adjudication out of this? I think Hamilton intuited this. You can sort of read between the lines of Federalist 78 and see that he understands this, and maybe he's reflecting back on the British practice. But what you get, if you have a politically independent body of adjudicators, and yet they have no power to enforce their own judgments, the strategy that these adjudicators will adopt, I argue, would be to try to resolve cases in a way that's perceived as being legitimate by the parties that appear before them. That will ensure, provide the best insurance that in fact their judgments over time will be obeyed and carried out by the political branches, because there'll be a strong a wellspring of popular support for the activities of these adjudicators. And I think that by and large that is what has happened, that the Article 3 judges maybe we slipped a little bit in the direction of imperiousness, but Article 3 judges have have developed a strong sort of storehouse of legitimacy based on their impartiality and their fairness in the way in which they resolve cases. The Due Process Clause was quite different. The Due Process Clause, there have been enormous debates about what the heck the Due Process Clause was understood to mean. But looking at the history, at least, it seems that there was a strong consensus at the time of the founding and for quite a number of years afterward that what due process means is that the government, either the legislative or the executive branch or the courts, the government can't take away your life, your liberty, or your property, understood in a kind of common law sense, without giving you a trial, a common law trial. And at least for the early years, common law trial was sort of assumed, perhaps a little too quickly, to mean jury trial. So how does this generate a fair and impartial adjudication? Well, the assumption was that common law trials, typically presenting factual issues to juries, would generate decisions that the public, the litigants, would perceive to be fair and impartial. We had that as a model at the time the Constitution was adopted. And so the Due Process Clause, at least in its procedural dimension, I'm not going to get into the debate about substantive due process, at least in its procedural dimension, the Due Process Clause was understood as a guarantee that any person who's being threatened by the government with taking away those core common law entitlements would be entitled to a common law trial, most likely including a jury trial. So part of my thesis is that these two strategies in the Constitution for ensuring fair and impartial adjudication have either been extremely watered down or have been weakened over time. Now, why does this matter? It matters for a couple of reasons. One is that, as other panelists I'm sure will discuss, when we become dissatisfied with ALJ decision-making or administrative decision-making or any other type of novel form of adjudication that has emerged over time, we naturally tend to look back to the Constitution to see if there's some way in which the Constitution can be used to kind of correct or redirect what's happening among these more informal forms of adjudication, whether it's A, B, or C. And secondly, that these constitutional strategies are templates that sort of have informed our understanding of what fair and impartial adjudication means. So even if we're just tinkering with the mechanics of administrative law, these models, I think, have a conditioning influence on the way we think about these issues. Well, part of my thesis is that there's been a significant erosion over time. Now, the Article 3 strategy was sort of incomplete from the beginning. The framers of the Constitution had no notion that they would have the authority to dictate to the states what kind of persons were going to be appointed to the state court judges, and the Constitution contemplates that potentially the Supreme Court would be the only federal court, and that Congress would not create any lower federal courts at all, in which case almost all adjudication would take place in state courts. So Article 3 was very incomplete from the get-go. Of course, the Congress did decide to create lower federal courts. But the Supreme Court came along and immediately started carving out exceptions. There was an exception for territorial judges that was upheld. There was an exception for military judges that was upheld. And so the court rationalized that these were Article 1 judges, not Article 3 judges, and the Congress had the power to create judges under Article 1. That was the first big carve-out. In 1856, in the Murray's Lessee versus Hoboken Land Company case, the Supreme Court, in an important dictum, said that there was also an exception for what it called public rights. And so if a matter involves public rights, Congress can decide to assign this to a non-Article 3 court. It was very unclear in 1856 exactly what public rights means, and it's been completely unclear ever since. Different opinions by different justices have offered varying definitions of what a public right is. In the Murray's Lessee case, a public right was actually the right of the executive branch to seize somebody's property without a judicial approval. So it involved the taking away of property by the government in the context of tax collections. But most cases seem to suggest that public rights were things like the decision to award land under land grant statutes or other types of things of that nature. The most recent decision, which I'm sure you'll hear quite a bit about throughout the conference, is Oil States Energy versus Green Energy, which says that a patent issued by the Patent Office is what the court calls a franchise. It's a property right in the nature of a franchise, and therefore it's a public right, and therefore it can be taken away from you by an administrative process subject to judicial review. And so that's the latest attempt to define public rights. I think all these attempts are to some extent problematic. The biggest exception were for administrative adjudication. And here the history's complicated. I've written about this before. Basically, when the first federal administrative agency, the ICC, was created, the assumption was that adjudications by ICC hearing examiners would be subject to de novo review in a federal court. Because these cases were private rights cases, they were cases between adverse parties, shippers and carriers, in which the ICC was sitting as the judge. And the assumption was that, of course, a case like that had to go eventually before an Article 3 court. Well, the problem was that if the ICC heard the case and then an Article 3 court heard the case, it took an extremely long time to resolve these cases. Shippers got very unhappy with this. Congress got unhappy with this, and Congress sent various signals to the ICC and to the federal judges that it wanted a more expeditious process. And through a long sort of process of stumbling around, eventually the solution that was reached was that the federal courts would treat the ICC like a trial court, and they would perform the role of an appellate court. So the federal courts gave great deference to the hearing examiner's findings of fact, but would decide questions of law de novo. Crowell versus Benson eventually seemed to sort of ratify this many years later in the context of a workman's comp type scheme. And the Administrative Procedure Act, importantly, also ratifies this. The Administrative Procedure Act's provisions for hearings and review very much contemplates that the facts will be found by ALJs or by other hearing examiners, and that the reviewing courts will give these findings of fact great deference and will decide questions of law de novo. Of course, deciding questions of law de novo kind of went out the window with the Chevron decision in 1984, when the Supreme Court suggested that when the law is not clear, which is the only type of case that ever gets to the appellate level, courts are supposed to give substantial deference to agencies' determinations of legal questions as well as factual questions. So the whole idea of this was not done under the public rights rubric, but just under the sort of evolution of administrative law. So there's been this tremendous erosion of the Article III strategy through these various maneuvers over time. What's left under Article III is basically criminal trials, to the extent we have criminal trials anymore. Most of them are plea bargained. Constitutional law adjudication, to the extent it goes to court, goes to an Article III judges. And takings of property by eminent domain is thought to be required, implicitly requires an Article III judge, but these are sort of implicit understandings rather than explicit holdings. What about the due process strategy? The due process, I think, is undermined not by shrinking the scope of due process, but radically expanding the scope of due process. We start out with the understanding that you get a common law trial, typically a jury trial, before your life, liberty, or property is taken. But then, you know, the administrative state comes along, and then various other types of things like revocation of bar licenses come along and so forth, and the courts eventually expand due process to apply to all forms of adjudication that affect people's property and liberty. The big change, of course, is that starting with Goldberg v. Kelly in 1970, the understanding of these triggering entitlements is vastly expanded. Property is expanded to mean not just conventional property, but also things like welfare benefits, government licenses, government employment rights, and so forth. This so-called new property cases. Liberty is expanded to include things like parole and probation and good time credits in jail. And so there's a vast expansion of due process rights starting in the 1970s. Due process explosion, many people call it. And as inevitably happens, when you vastly expand a right, you tend to dilute the form of protection you get. And so the inevitable starts happening. Matthews versus Eldridge in 1976 says that, well, you don't get a common law trial before these entitlements are taken away. You get whatever a bunch of judges decides using some kind of cost-benefit calculus would make sense from a social welfare maximization perspective. So it's no longer an individual right, it's sort of a collective right, and it's no longer even a right that pertains to certain beneficiary classes. It's a right that the judges think is going to provide the greatest net benefit, taking into account the cost to the government as well as to the disadvantage to the claimant. So after Matthews versus Eldridge, I think judges looking at the situation would start to ask themselves, as they should, why should we be the ones doing this social welfare benefit, social welfare maximization calculus? Doesn't it make more sense for legislatures and agencies to do this? And what we see, Dick Pierce, I think, is one of the first people to have discerned this, is that there's been a tremendous movement toward great deference on the part of the courts towards the procedural packages that the legislature and agencies have come up with. And so you get cases like Goss versus Lopez, decided just before Matthews v. Eldridge, which involved the question of whether a school principal can suspend a pupil for 10 days or less based on misconduct. And the court says, well, yes, due process applies here, but what sort of hearing is required? Well, the principal has to tell the student why he's being thrown out for 10 days and give the student a chance to tell, quote, his side of the story. So the common law trial has sort of come down to judges deciding procedural packages like that, which bear no resemblance to the common law trial at all. What is to be done about this from a constitutional perspective? I have sort of an evolutionary understanding of constitutional law. Mike Rapaport will give you a different perspective. In my view, the moves that could be made are largely firewall-type moves, that the courts could intervene if they were so desirous to sort of shore up the shrinking domain of Article 3 and could wall off the due process right insofar as it applies to conventional common law entitlements of life, liberty, and property. The way the Article 3 firewall could be built would be by intervening with this public rights notion, which was somewhat undermined by oil states, but I think in a way that leaves this open. Courts could say that insofar as public rights are really limited to sort of things that the government creates that did not exist at common law, new types of welfare rights, new types of permissions and programs, and new types of franchises, if that's the right word. But insofar as it involves a common law entitlement, Article 3 stands undiluted. This might mean that things like SEC hearings to impose civil fines on people would have to be heard by an Article 3 court, could not be heard by an administrative law judge. Another move that's open, I think, would be in the due process context to interpret Matthews versus Eldridge as applying only to these sort of new property, new liberty type cases, and say that with respect to more conventional types of government action in which things like your liberty is at stake or your property is at stake, the due process should be understood in terms of the common law forms of resolving these issues as they have evolved over time. So you would basically get a common law trial to satisfy due process in those contexts instead of whatever the political branches come up with and is deferred to by the courts. I'm not hugely optimistic about this happening. I think that what we see today is that most adjudications are conducted outside the purview of Article 3 and due process claims altogether. We have plea bargaining, we have arbitration and things like that. But I do think it's important that we preserve some understanding of these traditional notions of what fair and impartial adjudication means. And I would hope that there's some effort and perception on the courts that it's vital to do that. Thanks very much.
Professor Merrill kept referring to his, how would you describe your view of constitutional law, sort of evolutionary? Over years ago, you framed it as in an article as a choice between Bork and Burke.
Yeah, I'm a Burke, I'm a Burke guy.
Right. Professor Rapaport.
Well, thanks so much to Adam and the Center for inviting me. It's really a pleasure to come here and talk about administrative agencies and today the separation of powers. So this paper is part of a larger project I've been working on which attempts to apply a stronger separation of powers to administrative agencies. And this paper focuses on agency adjudication and argues that agency adjudicators should be replaced by Article 3 administrative courts. Discussions about applying a strong separation of powers to agency adjudication, they often assume that the only alternative to agency adjudication is if it were in the courts, would be a 19th century arrangement of generalist Article 3 courts that use ordinary federal court procedures. And then this alternative is quickly dismissed as impractical. Right? Critics argue that generalist judges would lack sufficient expertise, that ordinary court procedures would be too expensive and too time-consuming. But just because ordinary federal courts would be impractical does not mean we must give up on the separation of powers. And instead, I propose a Article 3 administrative court system. The courts would be independent of the agencies and would eliminate or greatly restrict agency deference. But the courts would also have expertise and would follow the streamlined procedures that agencies now generally use. So the system would allow a strong separation of powers, but would also have expert and low-cost decision-making. Well, let me begin by just sort of asking why follow the separation of powers, and I can only sort of briefly mention some of the reasons, but I think the core idea here is that the government does not have adequate incentives to pursue the public interest. Right? Government is coercive and it does not have to compete on the marketplace. And while elections and checks and balances help improve their incentives, I think the separation of powers is also needed. Without the separation of powers, there's just simply too much opportunity for agencies to take improper actions. Now, it's true, definitely true, that agencies are subject to judicial review and procedural requirements. But these checks still allow significant discretion to the agencies to act as they please in areas where they enjoy significant deference from the courts. And this deference then allows them to pursue a variety of improper motives, such as promoting an extreme ideology that the public does not share. Some agencies do that. Pursuing the interests of a political party. We often see that. Or just the interests of the bureaucracy. Now, a strong separation of powers addresses the possibility of these improper actions. First, the requirement that you have 3 distinct entities with different perspectives and different jobs needing to agree before you can hold someone liable for violating the law makes it much less likely that the government is going to be able to take an improper action. After all, there are 2 other entities here that may not share the improper motivation. Second, the separation of powers improves the incentives of government officials often. For example, if an official's impartiality as an adjudicator is going to be undermined when that official is also involved in prosecution or even policymaking. But when an adjudicator has no other responsibilities, he's more likely to be impartial. Unfortunately, the typical administrative adjudication violates the strong separation of powers. The ALJ is an agency employee. While ALJs do enjoy some protections, and I think they're very important, ultimately their decisions are reviewed by higher agency officials who may be involved in the prosecution or in policy matters. So while ALJs are an important check, they don't solve the problem. Moreover, the ALJs are far less independent than would be desirable. They're appointed by the agency, so they may reflect the agency's views. Their decisions are appealable to the agency, so that the natural human desire not to get reversed may bias their decisions. And their dockets are limited to a single agency, so they may display tunnel vision, the agency's tunnel vision. These are serious problems with existing agency adjudication. Now, of course, agency adjudication also has some important benefits in terms of expertise and lower decision-making costs. Now, defenders of agency adjudication argue that these benefits render agency adjudication superior to federal court adjudication, but these are not the only 2, or ordinary federal court adjudication, I should say, but these are not the only alternatives. Instead, we should replace formal agency adjudication with a system of Article III administrative courts. Agencies would bring enforcement actions before these courts, but the adjudication would be decided entirely by the Article III administrative courts. First, the court would make the initial decision, and then the decision would be appealed to ordinary federal circuit courts, much as they are now. Second, so the agencies would not review the decision. Secondly, the deference presently accorded to agencies would either be eliminated or greatly reduced as to facts, law, and policy. In this way, the Article III Administrative Court would actually be making the decision rather than rubber stamping or significantly deferring to an agency decision. In addition, the Article III administrative judges should be appointed by the President with the advice and consent of the Senate, and thus the agency would no longer have the power to select the adjudicators, the trial court adjudicators. Now, these administrative courts would address both the expertise and low decision-making cost issue. First, the judges should have expertise. There are 2 types of expertise here that's relevant. There's legal expertise, such as knowledge of the statutes and regulations in the area, but there's also non-legal expertise, such as knowledge of the science and policy considerations in the area. So let's start with the non-legal expertise. And the judges, I would say, should be divided into 3 groups, each with a different expertise in either medicine, science, or economics. And the person selected to be administrative judges would acquire their expertise either from schooling or from their prior career. And these judges would then hear cases involving their expertise, irrespective of what agency the cases came from. So they wouldn't only be hearing cases from one agency. The judges would also have legal expertise, not just non-legal expertise, but legal expertise. Now, in some cases, they would have prior knowledge from their prior career. They'd have knowledge of the statutes in the area. But in any event, they would hear only cases in their subject matter area. The economics judges would hear economics cases, and therefore would learn over time about the statutes and regulations within that area. Now, the administrative courts could also lower decision-making costs. The courts could use much the same streamlined procedures that are used in formal adjudication, such as limited discovery, limited cross-examination, and so on. Finally, the Article 3 administrative courts would also avoid some of the problems that derive from ALJs working only for a single agency, since they would hear cases from a variety of agencies. Now, another important question, important feature, I guess I should say, of transferring adjudication from agencies to Article 3 administrative courts would be eliminating or reducing deference as to facts, law, and policy. How much deference should there be? Well, let me here sort of present a sort of simple model, we can complicate it, that considers the additional expertise that the agency brings, on the one hand, and the separation of powers costs of conferring deference, right, of giving the decision to the agency, which also has enforcement authority. So under this model, an agency should be given deference if the expertise advantages it has exceed the separation of powers costs of deference. Now, given that the administrative courts have some expertise, but no separation of powers costs at all, strong deference in general is not going to be warranted. Right? And in my view, I'll just sum it up because I don't have time to go into all of it, there should not be any deference for adjudicative facts or findings of law, but there should be a kind of modest deference for legislative facts and policymaking. Now, I can't go into all of it, but let me at least explain a little bit to give you a sense of the argument for the 2 areas where I don't think there should be any deference, adjudicative facts and law conclusions or conclusions of law. So let's start with adjudicative facts. There, some expertise is definitely useful for the adjudicator, but the administrative courts will have that expertise. Moreover, the testimony is offered in front of the court, so it's in a good position to evaluate it. Plus, I think there's a little advantage for the agency based on maybe its superior expertise, but that small advantage does not outweigh the very significant separation of powers costs that giving it deference would create. So like other trial courts, I would say the administrative court should not confer deference as to adjudicative facts. It would make the findings on its own. Legal questions should also not be given deference. Let me just start out by saying I don't think that non-legal expertise helps when interpreting a statute. I know some people do, but not the way I think of statutes. Legal expertise here matters. That's true. And while agencies have more legal expertise about the particular statutes and regulations in their area, they have less legal expertise and less knowledge and skills about the law in general, especially as to, let's say, statutory interpretation skills. So overall, it's not clear whether the agency or the courts are going to have more legal expertise in these type of cases, but even if the agency does have more expertise, it would not be enough, in my opinion, to overcome the separation of powers costs. Thus, I would eliminate deference, Chevron, I even eliminate Skidmore, for the administrative courts, no deference given to the agency. Now, you might think that the elimination of deference would lead to a significant increase in the number of circuit splits. And that'd be a problem because, oh my God, all these new cases for the Supreme Court. And I have, in the paper, I go through a couple of ways of addressing this, but I think the best way would be simply for the Supreme Court, which has been taking an historically low number of cases, to simply review 20 more administrative law cases every year. I think that would handle it, but if not, there's some other alternatives I have in the paper. In conclusion, I believe that Article 3 administrative courts would be superior to our current system of administrative adjudication. These courts would allow for separation of powers, but they would also allow for expert and low-cost decision-making.
This 20 extra Supreme Court cases a year sounds like a nice jobs program for administrative law scholars. This is
Well, it does have that benefit, but I didn't want to point it out.
Professor Bomsai.
Should I get out?
Yeah, please.
Sure. Thanks, Adam, for inviting me, and thanks to George Mason Law School for hosting this event. It's a real honor to be on the stage with these three giants of administrative law and constitutional law, and I'm really privileged to be able to comment on their papers. And I'll just do them in the order in which they were presented, and suggest some thoughts that I had as I was hearing the presentations, and perhaps some questions that you all might be able to answer immediately after I sit down. So Professor Asimov's paper is really useful in reminding us that although we will tend to categorize adjudications to these two buckets, formal and informal, there's a vast array of different kinds of agency proceedings that occur in the category of informal proceedings. And it's very useful to think of those types of proceedings as breaking down into two categories, type B adjudications and what Professor Asimov calls type C adjudications. And the type B adjudications, as the paper points out, in some ways they're even more formal than adjudication that is conducted subject to sections 554, 556, and 557 of the APA. And that includes proceedings before the Patent, the Trademark Appeals Board, the PTAB, the Board of Immigration Appeals, Merit Systems Protection Board, as Professor Asimov's presentation pointed out. And so I have two reactions to this. And the first one is one that I'm sure he's thought about and would be able to explain to us. And it's just, why? What explains the fact that we have one set of formal proceedings, and I'm using formal here in the colloquial sense, that occurs subject to the APA's procedures, and then we have another set of formal proceedings, that occurs outside of the APA's formal, in the technical sense, procedures. Why do we have these two separate types of proceedings? And what explains, in some sense, Congress's decision to have or to allow these formal, in the colloquial sense, adjudications, type B adjudications, as opposed to something subjecting them to, the APA's formal, in the technical sense, procedures. And that led me to a thought about, what are the best practices? And this was a point that Professor Asimov's presentation was only able to touch upon briefly. And so one reaction one might have is perhaps one approach to the best practices is to subject all the other types of type B adjudications to the APA's procedures. Would that cause some sort of untoward ripple effect in terms of bad consequences? And what's the reason why we would not desire that as a policy approach? So that's one question, which is why do we do it this way? And could we just fix the issue to the extent there is an issue by subjecting these type B adjudications to the APA's procedures? The second question that I have, and this is actually something touched upon in the paper, is what are the consequences? What are the consequences for breaking the world out into type A, type B, and type C adjudications? And one consequence that came to mind to me, and is in the paper, is, we've already spoken about the Chevron doctrine, the doctrine under which agencies get deference for the ambiguous statutes that they enforce. And as we know, after the Chevron decision and a decision called Meade, the court said, well, that's only true for some subset of agency decisions that are set out in a certain type of form. And the paradigm cases of the type of form that the agency would use to achieve deference would be rulemaking and what Professor Asimov's called type A adjudication, so formal adjudications under the APA. And I assume that the approach that Professor Asimov would want to put forward is that type B adjudications also get the same type of deference as type A adjudications. And so I wonder if we could say a little bit more about what the theory for that would be. What's the normative basis for treating type B adjudications comparably to type A adjudications in this very important context, and perhaps just other consequences that flow out of breaking out the world of adjudications into three categories as opposed to two. So those are my two thoughts on Professor Asimov's paper. I'll move on to Professor Merrill's paper, which I think is very interesting in highlighting this relationship between the Due Process Clause and Article 3. And at least to my mind, and I wonder if Professor Merrill agrees with this, there's a sense in which we might think of these two provisions. There's been a contraction of the use of Article 3 to mediate the role between judges and agencies over the course of the 20th century. And at the same time, there's an expansion in Goldberg versus Kelly, and then a later contraction of the role that due process plays in figuring out the relationship between agencies and Article 3 judges. And so, one way to approach this is to think of what might be thought of as the revisionist approach to administrative law from the 19th century. This is an approach that various scholars have put out, and I'll just explain it really quickly here. And I wonder if Professor Merrill agrees with this idea that this was how things were done. So one way we can think of the role that courts play versus agencies is to try and understand a distinction between rights and privileges, which mapped on in some ways to this distinction that Professor Merrill explained between public rights and private rights. And so rights and privileges, what I mean by that is that there was some aspect of the government's interaction with its citizens that we would define as rights. And if, in fact, the government infringed upon your right, then the Constitution provided you a full-blown, full-dress Article 3 trial subject to common law procedures in a court, and whatever an administrative agency said about your right was in some ways irrelevant. You were entitled to adjudication before a court. By contrast, we might think of certain ways in which the government interacts with its citizens as affecting the privileges of the citizenry, and so conceivably one would have thought of certain things that the government was doing during the 19th century, like providing veterans benefits, as providing privileges to the beneficiaries of those programs. And under those circumstances, the way, as I understand it, the revisionist account approaches things is that for rights, you got the full-blown Article 3, full-dress common law trial. For privileges, you basically had no rights at all. There's no rights whatsoever. And so neither Article 3 nor due process require the government to treat you in any particular way when it was dispersing these types of benefits. And so, first of all, I wonder whether Professor Merrill thinks that's an accurate account of the way in which the 19th century courts approached this question. And second of all, I wonder whether if, in fact, we are to give any kind of force to the notion of Article 3 as a limiting principle on what administrative agencies can do, or due process as a limiting principle, we have to reapproach and try to understand a distinction between rights and privileges. Is there any other way to conceptualize this area other than thinking about the problem in those terms, in some sense? So that was my overarching reaction to Professor Merrill's piece. And I'll turn to Professor Rapaport's article. And I think Professor Rapaport's article is a really interesting article that asks us to think about to question our first impressions about the system of generalist Article III courts and specialist tribunals within the executive branch that we've developed. And it reminds us that Article III imposes certain requirements on Article III courts and judges, namely that they have good behavior tenure and they have undiminishable salary. But there's no requirement that Article III judges be generalists. It just so happens that most of our Article III judges are generalists. You might think that that's happenstance. That's an accident of history. It's not necessary. There's no requirement built into the Constitution itself. And so I have two reactions to the paper. And the first, you might think of it as a historical reaction, and that is that, in fact, at various points in our history, there were specialist Article III courts that were created. And in fact, if you look at the 1929 book by Felix Frankfurter and James Landis, The Business of the Supreme Court, much of that book deals with the notion that there was this rise of specialist Article III courts at the time in 1929 when the book is being written. In 1933, we have the Administrative Committee of the ABA, the American Bar Association, that's putting forward various ideas that will ultimately become the Administrative Procedure Act in 1946. And one of the ideas is that there should be a specialist administrative court, which was something that members of the Roosevelt administration and the New Deal thought would be really crippling and stifling for the administrative state. And so another historical tie-in. We've had other specialist courts, Article III courts in the past. So there's the Commerce Court, which I'll return to in a moment. And there's the Federal Circuit that we have right now. And so, one might think, well, do those courts work well or badly? And we've actually had courts go in one direction and the other direction, in the sense that there was an administrative body called the Board of General Appraisers that was created in the 1890, that becomes the Court of International Trade that we live with today in 1980. And the Court of International Trade is, in fact, an Article III specialist court. So one might think, well, does the Court of International Trade work well? Was that a good move or a bad move? And the Court of Federal Claims, by contrast, it starts off in 1855, and after some stumbles upon the way about what's its status, is it Article III or non-Article III, it is understood to be an Article III body before Congress switches it over in 1982 to something else. I'm not exactly sure what it is right now, but it is not an Article III body. So it's a body that moves in the other direction from the Court of International Trade. All of these historical examples may inform the question whether creating Article III specialist courts just are a good idea. Are they a good idea? And I'll just leave Professor Rapaport with the thought that, at least for some of these Article III specialist courts, there were concerns. And so the Commerce Court is a prime example that the same notions of agency capture, the same problems that occur with specialist administrative bodies also infected those Article III bodies. And I wonder whether that's something that you have any thoughts on. So once again, a really interesting set of papers, and thanks so much for allowing me to comment.
Thank you. Well, a lot for our authors to chew on, and I do want to get to audience questions as well. First, give each just a brief opportunity to respond to what's been raised so far, and I do want to throw one more question, a very general question, into the mix. All three of the papers talk about, among other things, notions of fairness and legitimacy of administrative adjudication. And I've always wondered, to what extent has the court's perception of fairness in this context and the public's perception been informed by the terms we choose, right? By calling it adjudication and by calling them now administrative law judges, it would seem to carry with it some basic presumptions about impartiality and so on, informing the public's view of fairness. So what's in a name, and would changing the names of these things have any effect on the public's perception and the court's perception of legitimacy? So why don't we begin with Professor Asmo?
Sorry. So just responding to excellent questions. Professor Bomzai asked, well, why not just take all your Type B proceedings and dump them all under the APA and merge Type A and Type B. So a bit of history on that is that in 1992, the Administrative Conference did a really gigantic study of this whole field, and they did recommend that quite a few of the Type B proceedings, including immigration and those which award serious civil penalties, should be switched to Type A, in other words, heard by ALJs rather than AJs. That went exactly nowhere. And the reason why that is resistance by agencies. To be perfectly candid, agencies absolutely hate ALJs. They are not willing to, if they can possibly avoid it, to have their hearings conducted by ALJs because of all of the restrictions on hiring. Now, the restrictions on hiring have changed quite radically. Other papers are going to talk about that because of a recent executive order by President Trump. Taking it away from the hiring, away from the office of what do you call it? It's eluding me here. But it's
Personnel
been
management. OPM.
Oh, OPM. Thank you. But at any rate, up until now, OPM did the hiring in a very inept manner. ALJs, of course, can't be subject to performance evaluations of any kind. They're the only federal employees that can't be subject to performance evaluations. They're very highly compensated, and in general, agencies would like to avoid them. And so they're not willing to be subjected to Type A of the APA if they can possibly avoid it. And I think you'll find very, very few recent additions to the category of Type A and lots of recent additions to Type B. It's just for political reasons. The regulators don't want to be subject to the APA, and there's no to the APA adjudication provisions, and there just isn't any political likelihood that that's going to change. So why it is that some are Type A and some are Type B is like a completely historical anomaly. It just has happened that way, agency by agency, combined with the resistance of agencies to being included under Type A.
Professor Romero?
Yeah, quickly. So I agree that I think I agree with the characterization of 19th century administrative law as having this sort of fundamental distinction between rights and privileges. The Lands Office is the most striking example of that, where the Federal Lands Office was one of the biggest operations that the federal government had, and the understanding was that they could resolve claims under the Preemption Acts or the Homestead Acts basically as they saw fit, and there was no right of judicial review or challenge of these decisions whatsoever because the government was granting a privilege. Once the land was granted and somebody received a patent to it, then it became a property right, and you couldn't take it away without some kind of Article III determination, or at least a full common law type trial. So there was a very stark distinction adopted there. Pensions, I think, were similar and so forth. Now, in the modern era, the Supreme Court very extravagantly said, I think in Board of Regents versus Roth, that the wooden distinction between rights and privileges has been completely abandoned. And then the court proceeded to draw a distinction between statutory entitlements and non-statutory entitlements, which is just rights and privileges redescribed under different terms. So it seems like something like that is pretty hardwired into the way of thinking about these problems. And I guess my thinking about both the firewall for Article III and for due process does draw heavily on that. I wouldn't say that it's a bright line that's been fixed for all time. I think there's sort of some kind of evolution in terms of how we think about rights and privileges. There'd be some problematic cases. You know, if you get a license to practice as a doctor or a lawyer, and then so the government wants to take it away, since that license is sort of a gateway to performing a common law livelihood, I think you could make a fair argument that that's not on the privilege side, but the right side. I think the patents are the same story. Patents have almost always been understood to be property rights that can only be taken away through some kind of trial or Article III type proceeding, and the oil states case in that regard, I think, is highly revisionist. As to your general question, Adam, it's quite interesting. I mean, I think it would behoove people like me, I guess, to look more closely at some of this psychological literature by Tom Tyler and others as to what causes people to think that a adversarial proceeding in some sense is legitimate. And I suspect that it has it synchronizes to some degree with what lawyers think of, but not perfectly. I think the public probably has a looser understanding of when they've been treated fairly or impartially by the government or some other type of hearing entity. And the question would be whether that public understanding has been shaped by the law or whether the law reflects that public understanding. I'm sure it's some of both. But that would be another interesting sort of window on this whole question.
Professor Rapaport?
Okay, so those were great comments by Professor Bonzai. So we'll start out, the New Deal rejected the idea of administrative courts because they thought it would be too constraining. Absolutely, that's right. I think that supports me. Yes, this would be a limit on administrative agencies. This would be a limit on sort of, super activist government. That's right. But there are real problems with administrative agencies and super activist government. So no surprise that the agencies aren't going to like it. In fact, as Professor Asimov says, they don't want even ALJs. They're certainly not going to want Article III courts. But what they want, I don't think is what's necessarily best. So it's quite a good idea to sort of take a look back at some of these prior courts and how they operated. The Commerce Court is the example that people point to. It was only a short-lived example. My sense is, and I haven't really explored it more generally, is that there were a lot of complaints at the time that led it to being sort of eliminated, but scholars, at least some scholars who've gone back, said actually the court decided the cases correctly. They just were unpopular with various interest groups. So that wouldn't suggest they were a bad court. It would just suggest that we've got some problems of making this stick politically. In general, I think it's a bad idea. It's a bad idea to have these courts be too narrow. On the one hand, you do want some of the features of generalist courts. Right? You don't want them limited in their sort of agency perspective. You don't want interest groups to be able to figure out which way the judges are going to decide in particular cases, which is much easier to do if you're in a narrow area. So on the one hand, you want to make them as generalist as possible. On the other hand, the more generalist they are, the less expertise they have. So you've got a trade-off there, and my suggestion that we have sort of three groups, some economics people, some medicine people, some science people, is to, on the one hand, make them generalist enough so they're not limited to a particular agency, but on the other hand, have some kind of expertise. So that's the kind of trade-off with those two things. So to a certain extent, I guess I would say the type of arrangement I'm talking about is quite unprecedented. On the other hand, some of these courts do a very good job. Just imagine, people just take it for granted that we've got a tax court. How many people would say, well, what we really ought to have is, have the IRS be adjudicating these things on their own. Just when we're sort of thinking about this on a kind of intuitionist basis, some areas seem, because we got used to it, but some areas seem, it would really be problematic to get rid of the tax court. And other areas, people are just sort of comfortable with administrative agencies making these decisions. And I think it's sort of interesting to think about why that is, why, aside from the fact that that's just the legal landscape that we happen to have.
Well, we still have a little more than 10 minutes for questions from the audience, and especially with students in the audience. If any students have questions, please raise your hand and we'll give them priority. There's microphones on each side of the room that will be brought to you. The first question, Jim Tosey in the back. Anybody want to ask the second question? All right.
Hi, thank you. I'm Jim Tosey. I want to compliment the center for having this this dialogue, because I think within the executive branch, the guts of the administrative states is rulemaking and adjudication. And with respect to rulemaking, it took 50 years and a lot with Ambassador Gray's help. The whole idea of centralized regulatory review put some order to the rulemaking process. So what remains then is the adjudication process, and at least from where I stand, I haven't seen a comparable action on adjudication measures as opposed to what was done on rulemaking. But given that, I have a question for Professor Asmo and possibly implement about views of other members of the panel, and particularly Professor Rapaport. If you look at the adjudication, I think when the Professor Asmo's report came through ACUS, I spent a lot of time reviewing that report, and it's really a treatise that I recommend everyone read. And his breaking informal rulemaking into two categories, B and C, is extremely important. And I say it for the following reason, is that A and B are either governed by the APA or they have evidentiary hearings, or both. C doesn't have either. So my question is to the professor, and I remember reading your paper at length on best practices for B. I just don't remember you doing anything on C, but I could have had an earlier draft. So my question is this: as written now, category C, which is free from evidentiary hearings and also governed by the APA, as we go forward, should C remain that way? Should adjudications taken under your category C continue to be free from being governed by the APA and free of evidentiary hearings?
Jim, thanks for that great question. So in the forthcoming book, which you'll all want to have in your personal libraries, I know, published by ACUS, I do have a lengthy chapter on C adjudication. So that's no legally required evidentiary hearing. And in fact, no hearings at all. It is a vast, vast area. There's just thousands. I mean, how would you even track them down? How can you even write about them? There isn't any list of them anywhere. You stumble on them here, there, and everywhere. Every now and then they pop up in some case. They're astoundingly diverse. I mean, among a few that we could mention are hearings resulting from grant making and loan making by the federal government. So if you're very unhappy that the National Science Foundation rejected your loan application because you feel the reviewer was biased, well, what can you do about it? Well, there like is a procedure, but it's not an evidentiary hearing. There's so many of these, so diverse, that you could certainly would not want to subject them to any overall statute. What the book does is try to come up with best practices for this vast area, extracted from some informal due process cases. People have mentioned Goss versus Lopez, the due process case about suspending kids from school for 10 days. Due process does apply, but very, very modest type C type conference is all that's required. So taking those principles, plus sections 555 and 558 of the APA, which do apply to them, it's possible to come up with a set of best practices. Attempts to do this in the past haven't gotten much traction. I don't know if my attempt will do any better. But I think that's as far as you could possibly go with it. It's just way too diverse to subject to any particular template.
I just wanted to say one quick thing. So you mentioned that cost-benefit analysis is sort of through OMB is a way we've sort of centralized and checked regulations. I think that's better than the alternative. But I just want to say there's another piece of this project that I didn't talk about at all here today, which basically says, look, if we wanted to introduce more separation of powers, we've already got a proposal out there. It's the Reins Act. Now there's some problems with respect to the Reins Act, of course, being the act which would have Congress vote up or down on significant regulations that are proposed. I think there's some problems under the Reins Act, and it needs to be kind of, tweaked and reformed, and because it wouldn't do, it's open to a lot of circumventions now as written, but that's another piece of this. So you could have Article 3 administrative courts on the one hand, and you could have a new and improved Reins Act on the other.
I'm just very curious, since we're almost out of time, a quick question for Professor Asimov and Professor Merrill. I'm just curious for your reactions to Professor Rapaport's sort of broad structural reform proposal. My own reaction is a very sort of, sort of the low-hanging fruit question would be, when judicial confirmations for the last several presidents have been such a politically fraught thing, the idea of creating a new court that would then open up a whole staff of Article 3 judicial appointments that would be extremely consequential. It could be an interesting political fight, let's say. But I'd be more interested in hearing Professor Asimov's and Professor Merrill's thoughts on the proposal.
Well, I'm glad you asked that. I've just been composing in my mind the letter I was going to write to Michael about my criticisms of his piece, which I very distinctly disagree with. Let me just mention this approach. So of the papers here, and of all of them, there wasn't a comparative word said. All other countries deal with the same problems. And if you look at, and Michael, I think your paper, the problem is an excluded middle. There's a gigantic alternative to combined function adjudication or sticking it into Article 3, and that are tribunals. Now, you mentioned the tax court. That's a great example. It's not an Article 3 court. It is not a court at all. It is an administrative agency. It's Article 1, but it works great. No one finds any fault with the tax court, and that's the model that I think, Michael, you should be pursuing. That is tribunals, administrative agencies that only adjudicate. In Canada, they have a tribunal for every combined function agency. In England and Australia, single overarching tribunals that cover everything but with specialization, just like the system you described for Article 3. It's, in my opinion, the tribunal approach, highly respected in these countries. Do you know that the English Social Security Tribunal takes 22 weeks to decide a Social Security case? 22 weeks! It takes us years to decide a Social Security case. The tribunal approach is really a valid way to tackle some of the problems of adjudication, and I'm planning to discuss that with you, in a private communication. But that's something you need to look at rather than shifting to Article 3. I mean, how many new Article 3 judges would you be hiring? I figure hundreds. You probably triple the size of Article 3. You got to build marble courthouses for all of them. And you didn't mention the word jury, either of you guys. Juries, you want juries to hear all these cases, right? You're going to have to if it's under Article 3. So take a look at tribunals.
Well, how about Professor Merrill, and then we'll give Professor Rapaport the last word.
Three quick points or questions. One is, there's another alternative to a Article 3 specialized court, which would be the bankruptcy judge or magistrate judge model. You could, in some cases like with SEC adjudications or patent adjudications, you could create specialized magistrate-type judges, which would be subordinate to Article 3 judges. They would be appointed by Article 3 judges, so they'd have a great deal of independence, but they could also be, as bankruptcy judges do, have considerable expertise. So that might be another model. I think other people have proposed this to consider rather than Article 3 judges. Secondly, the Chenery Doctrine, Chenery 2, I think it is, says that agencies are free to make policy either by rulemaking or by adjudication. The Labor Board is a classic example of an agency that's made policy by adjudication. So your proposal, I take it, would nix that. So you'd have to have those agencies use rulemaking. I guess I'd be okay with that. It'd be kind of a fairly substantial reform. But you'd have to sort of take that into account. And the third point, also picking up on the Labor Board and echoing Adam's comment, I would be a little bit wary about the confirmation hearings for the Labor Board judges, since it'd be like a Supreme Court appointment in the sense that it would have a huge impact on something in a controversial area of policy, and so we'd have all sorts of surprise witnesses appearing in Labor Board confirmation hearing, Labor Board judge confirmation hearings, just like we do with Supreme Court nominations.
Michael, the last word?
Yeah, so a couple of things. First of all, I don't think very much turns on whether these are actually Article I courts or Article III courts. So the key consideration here is that if they are Article I courts, that the court has the final say, not the agency. So, Article I court, as long as, they've got a long, 15, 20-year term, I have no particular, I don't think that's, there's going to be I intended to have a footnote, but ran out of time, sort of saying that in the piece. But so I agree with you there that there's no particular problem there. And if we wanted to use a bankruptcy judge type model or anything that's genuinely independent, I think would be fine. As to Tom's point about absolutely right, I would get rid of policymaking in adjudications. I would have the agencies pass policy in the form of rules, and then rules would be subject to a kind of Reins Act arrangement. The confirmation for labor judges would be very contentious. But of course, I'm not arguing for labor judges. I'm having there's sort of economics ones. They're who are going to be citing not just labor cases. They'll be deciding a whole bunch of other things. And so there's going to be contending interest groups, and some groups are going to like, for one reason, sometimes you're not even going to be able to tell what their position is on labor issues because they've spent their career doing FTC type things. So
It would be wrong to answer a hypothetical question about that, right?
Well, we have run out of time. In fact, we've gone a little bit over. I do want to, I see there's a question. I'm sorry we didn't get to it. So we'll take a break until 10:47. We'll reconvene with the second panel. But please join me in thanking our speakers.